Good morning, good morning, good morning to everybody. Let me take this little banner off my head because it's not necessary right now. Welcome, 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 welcome. Shout out to everybody in the chat. Shout out to everybody. I've got where it says, I'm excited for this live. You guys were in the comments saying, I'm excited for this live. I want this live to happen. Shout out to you guys, all the beautiful, wonderful members. Welcome. I hope everybody's going to have a great start to their week this week. It's been a crazy month. All right. We about to start the new month. New month, new outlook, new something, new opportunities to do something with ourselves, right? Shout out to everybody. All right, so I have Mr. Matt in the studio, right? He's waiting for us. He's going to review and give us this objective view on this complaint, not Rabbit's view, the objective review. Okay, just keep that, or view, keep that in mind. I've also pinned his channel name in the chat so you guys can check him out. Make sure you subscribe, go over there and show him some love. He's going to be dropping some videos hopefully pretty soon. And it's always kind of nice to get, I'm very thankful that we have him here because it's shout out. We have some attorneys here that are members or subscribers, Lady Justice, Mystery Lawyer, Mystery Maven, all these wonderful Itzhak's Baby Girl, all these wonderful legal professionals that can help us and can be a resource to us when we need them. So shout out to them and thank you to Mr. Matt for coming through. How are you?
Doing well. Doing very well
Yes.
today.
You look great. Shout out
Well,
to
thank
you.
you. I hope I don't look too intimidating, right?
No. No. You're doing just fine. Shout out to you. So we
Little
got the
inside joke there.
right. So we got the complaint here, and I want to thank you so much for being here this morning and even helping me out here in this situation, getting a different voice to this, right? Not just
Yeah.
Rabbit's voice, but a different voice. Shout out to you and thank you for doing that. Do you want to show us the complaint and just kind of let us know kind of what the rundown of it or what your thoughts
Yeah.
are?
Go ahead and pull up the complaint, and I'll show you what we're talking about here.
All right. Let me see if I can pull it up here. There it
All
is. And I'm going to put these comments down. If you guys have questions, feel free to ask them. If the chat goes too fast, and I'm going to have to, dig through these comments, but we might not be able to pull them up all the way. Just letting everybody know.
Okay. So this complaint has been filed in the United States District Court for the Middle District of Tennessee in the Nashville Division. Let me explain what that means. Of course, United States District Court is the court of original jurisdiction for most cases, meaning if you want to originate a suit in federal court, you're going to end up at the district court. And then if you lose there, you're going to appeal to the Circuit Court of Appeals. And then if you lose there, you would appeal to the Supreme Court of the United States. Okay. So Tennessee has 3 districts: the Western District, the Middle District, and the Eastern District. And just one second. One moment. Yeah, I'm telling my son to shut my office door because I'm having trouble hearing on my end here from the background out there. But anyway, so the Middle District is where Nashville is. The Eastern District is where Knoxville is. The Western District is where Memphis is. Okay. And then each district has various divisions. The Nashville division covers a few counties in there. The Columbia division covers another few counties, but you get the picture. All right. So this is being filed. By the way, I'm licensed to practice in Tennessee and I'm licensed to practice in Mississippi. And in fact, I have appeared. I'm admitted before the Middle District of Tennessee. In fact, I have a couple of cases pending before the various judges in question here. I still have some cases there.
Okay.
Can't get into those cases and whatnot, but I will say that I'm kind of familiar with how things operate there. Not as well as I might the Mississippi federal courts that I practice the most in, but I do have some more recent knowledge here. And so they have decided to file this suit in federal district court.
Okay.
Now, let's look at this very first paragraph. And this is a thing called, it says, this diversity action arises from the defamatory and tortious conduct of defendant, well, I'm going up too high, I'm sorry, from defendant Ryan Upchurch is explained below. Now, what a diversity action means is that there are two ways you can get into federal court. You can get into federal court if you're suing based on a federal statute that gives you a private right of action. So, for example, there's a new federal law that was passed last year that says if you have ever, if somebody has taken intimate visual depictions of you and put them on the internet or something like that, you can sue them in federal court for doing it. Okay.
Okay.
Be a federal question type situation. So if let's say somebody in Mississippi, a boyfriend in Mississippi put pictures up of his girlfriend in Mississippi online, then you could have a suit in federal court because federal question in this hypothetical is implicated. All right.
Right.
When you get into a diversity action, you're dealing with state law claims, but those state law claims have to be between parties from different states. And that's what diversity means. In other words, every plaintiff has to be from a different state than every defendant. And you have to sue for more than the jurisdictional minimum amount, which in this is currently $75,000. Okay. So in this particular instance, if you go down to, we're going to skip on down to the parties, paragraph 23, 24, and 25, we see that David Robertson and Daniel Rodni are both citizens and residents of California. So you have two California residents on the plaintiff side, and you have one Tennessee resident on the defendant side. So everybody, every plaintiff is from a different state than every defendant. And we later see that they're asking for more than, it says here in the next paragraph, they're asking for more than $75,000. So this gives you the right to come to court in federal district court because you are invoking the diversity jurisdiction of the courts. Now,
so it meets those two components, basically.
It meets those two components.
Gotcha.
So, in other words, the Robertsons had the choice. They could have filed suit in, I believe, if I'm not mistaken, this guy, I won't say what county this guy lives in, but whatever county in Tennessee that he lives in, he could have filed in circuit court there. Okay. Mm-hmm. Or he could have filed in a federal district court in Nashville. Those are the two options. Okay. So that's the first thing. Now, the question is, at this point, we get into a situation how, what was the strategy and the determination of why you would want to file suit in federal district court as opposed to state court? And for that matter, why would you file in Tennessee as opposed to filing in California since they live there? So let's start with that part first, the California aspect. In order to sue somebody in a state, the court has to have personal jurisdiction over that person. So I'm going to use me as a hypothetical. In all of my life, I have never been to North Dakota.
Okay.
In all of my life, I have never had any contacts with North Dakota. So if anybody wanted to sue me in North Dakota for anything, even if I were liable, even if I were at fault, the state of North Dakota wouldn't be able to enter an order against me because I've not done any acts or made any communications or said anything to anybody in that state. And so therefore, there is no jurisdiction over me in that state. Well, the same question might apply here with respect to Ryan Upchurch in California. Yes, he's been talking a lot of crap on Facebook and I'm sorry, on YouTube. Mm-hmm. He's been talking a lot of smack. He's been saying a lot of things about the Rodnis and the Robertsons. But has his comments actually been directed to the state of California? Okay. All right. And that's a fair legal question. And it's one of those questions that if you look at the YouTube videos and whatnot, it may not meet that threshold. And if you don't have that threshold, then you don't have minimum contacts. And if you don't have minimum contacts, then there's no way in the world you could sue in California. So that means they have to find a forum or a venue where, see, Claire says, you didn't send mail to North Dakota from Hawaii.
Sorry about the Andracchio.
We can't get into that, Claire. That's for another time.
Yes.
Yes, way to go, pal. I appreciate that. So, at any rate, in this particular circumstance, the as crazy as what Ryan Upchurch may have been saying was, he may not have actually directed his comments enough to the state of California for the state of California to just grab hold of him. And so the safer bet, considering the fact that we have a shorter statute of limitations, might have been to go ahead and file suit in Tennessee, because if you live somewhere, they have personal jurisdiction over you no matter what. That's called general personal jurisdiction. So they decide to sue him in Tennessee, probably to hedge their bet, probably to make sure that they've got personal jurisdiction. So now the question is, all right, which court do we file suit in? They could have filed suit in a Tennessee circuit court, in a state circuit court, or they could have filed suit in a federal district court because they have the requisites for diversity jurisdiction. Now, there are advantages and pluses and minuses in going in either court at any given time. For example, there's one plus in going straight to state court as opposed to federal court, because you can immediately start doing discovery normally. You can immediately start sending interrogatories, requests for productions, noticing depositions, things along those lines in state court. Can't do that in federal court until you have a Rule 16 conference. Okay? Until the judge says, all right, we can start discovery. But there's a downside, especially in state law defamation cases, to file suit in a Tennessee state court. And that's because the state of Tennessee has an anti-SLAPP statute. Now, SLAPP means a strategic lawsuit against public participation. And when you have an anti-SLAPP case, what happens is, if you file suit against somebody in Tennessee, in a Tennessee court, and you are suing them for anything that they have said online or done online or done anywhere for that matter, that it implicates a First Amendment issue, like a matter of public concern or a free expression of religion or anything along those lines, then the defendant can file a motion to dismiss, a special motion to dismiss under the anti-SLAPP law. And that is a very powerful motion because it immediately suspends discovery. That means that, so let's say hypothetically, if the Robertsons and the Rodnis had filed suit against Mr. Upchurch in state court, Mr. Upchurch could have immediately filed an anti-SLAPP motion, and that anti-SLAPP motion would have stayed all discovery. And then the Robertsons, the Rodnis would have to put up or shut up and start showing, through affidavits, through sworn testimony, through anything along those lines, evidence to back up the essential allegations of their complaint. Okay. But that's only after Mr. Upchurch files the anti-SLAPP motion. And then even then he has a burden first. The burden is on the defendant to file and say, okay, this is implicating a matter of public concern. It has to do with my religious rights, has to do there's a list of things in the statute. And if you're talking about something that is being covered around the world, it's an international news story, then invariably the first box is going to be checked. And so the burden would shift to the defendants, to the plaintiffs rather, to prove that they have a prima facie case for what they are alleging. And so they would have to start producing their proof if an anti-SLAPP motion was provided. And if they didn't have enough proof to back up what they were saying, then the case would be dismissed right then and there. Okay.
Wow.
All right. But if they had enough proof, then Mr. Upchurch could come back and assert some defenses, like the affirmative defense of truth, or he could assert some First Amendment defense or some other affirmative defenses that are covered by the law. And then the judge would determine, based on all of that, whether or not the plaintiff has met the burden to go on. And if they do that, great, the case goes on. Now, what's interesting about the anti-SLAPP statute in Tennessee is that whenever the judge rules on that motion, for whoever he rules for or against, that is immediately appealable to the appellate courts. Okay? So you can't get any discovery on an anti-SLAPP case probably for months or years, because everything's going to be held up in the process of the anti-SLAPP and until you have the appeal taken care of on the anti-SLAPP motion before the Tennessee Court of Civil Appeals, okay? Or maybe even the Tennessee Supreme Court if they decide to take it. So in that context, if you are a defendant, an anti-SLAPP motion is your first go-to thing. And as a plaintiff, you want to avoid anti-SLAPP motions if at all possible, okay? So you know that if you file your complaint in a Tennessee state court, you are going to be subject to that anti-SLAPP statute. The question is, are you also going to be subject to that in federal court? Now that's interesting, because let's go back to California for a moment. California also has an anti-SLAPP law. It's a little bit different. But the Ninth Circuit Court of Appeals, which covers California, has said that they are going to go ahead and allow the anti-SLAPP motion to be heard in federal courts in the Ninth Circuit. So if they had been able to file their motion in their complaint in California, and Upchurch had done a anti-SLAPP motion there, it wouldn't have mattered if it was in state court or federal court, because the anti-SLAPP motion would be heard. Okay. However, in Tennessee, the Middle District of Tennessee has says anti-SLAPP law don't apply to us. So all that talk I told you about being able to file a motion that stays discovery, a put up or shut up type situation, and having the appeals and that kind of stuff, does not apply in the Middle District of Tennessee in the federal courts, because the federal district court says, hey, we're a federal court. This implicates the procedures, and not this. This is not a substantive law situation. It's a procedural law. Plus, on top of that, we have the supremacy clause. You don't, so you can't use this law in our court. So by filing this in federal district court, the Rodnis and the Robertsons have avoided the possibility of an anti-SLAPP motion. Okay. So that means that it's just as if they had filed it in a state with no anti-SLAPP law. Okay. So that is a big advantage for the Robertsons and the Rodnis in that respect.
Strategy. All strategy. Mm-hmm. Oh, man. Okay.
All right. That's why they probably wanted to do that. Now, let's go into the complaint a little bit more. Mm-hmm. And we're going to go down here and we'll see. All right. I'm going to see if I can minimize my complaint just a little bit for my benefit, so I can actually see. Oh, well, I'm having problems.
And we can remove ourselves from the screen if you want to make it bigger.
It's no. I see this. Okay. So we're going to go down here and hit some of the highlights. There's an introductory paragraph here that talks about the backstory of Kiely Rodni. And by the way, just for full disclosure and all that kind of stuff, I'll be honest with you. Prior to this week, I had really not even paid attention to the Kiely Rodni story.
Okay? Kiely Rodni.
Kiely Rodni, yes. As you can tell, I'm Southern. I mispronounce everything. Everything's Longy or something. Okay? Kiely Rodni, I mispronounced her name, and it's because I'd never really followed this case. And I don't know the Upchurch guy. I'm certainly not representing him. I gather from watching his videos, he would be a very problem client to represent, just because I don't think he would listen to counsel. But that's just my opinion. He may actually that may just be his persona, and he may be a respectful young man when he's talking to his attorneys, and his attorneys he may do everything they tell him to do. I don't know. But just my gut watching his videos, I figured he'd be a handful. I don't know. And I feel for his attorneys. But we going down here, it talks about he began posting the disappearance of Kiely in August of 22. It talks about the true crime stuff. The young lady disappeared after a party in August of 2022. She ended up, as we all know, driving into, I guess, a lake or something, and she drowned and died. Yes. God bless her. God bless her family. And then Mr. Upchurch was, chiming in on this, in fairness, like we are. Mm-hmm. But he was going into a lot more speculation about what really happened. And they're saying that he made a lot of outlandish claims. Now, let me back up for just a moment. This complaint is, this complaint are the allegations that have been filed by the Rodnis and the Robertsons. Now, objectively, and like I said, I don't know that much about this case. These allegations may be all true, they may be all false, or they may be all or somewhere in between. Okay, I don't know. I have no way of knowing. I'm a lawyer sitting in my office in Tupelo, Mississippi, and I don't really have a dog in this hunt, and I don't know what's all the facts are. However, when you're testing a complaint, when you are testing a complaint for its sufficiency, the federal court assumes that every well-pleaded fact, every well-pleaded allegation in the complaint is true. Okay, just for the purposes of testing its sufficiency. So if this complaint somewhere says the sky is red, or the sky is purple, or the sky is yellow, all right, that is a factual allegation. And if that factual allegation, for the purposes of the complaint, is going to be deemed true as we analyze this, okay? So I am analyzing this complaint as if all of the allegations are true that are factual, okay? Not conclusions, but factual. And I say that only because I'm not picking a side on this one way or the other yet. This is their volley. This is the plaintiff's first shot. And we're giving them the benefit of everything that they are saying is true to determine whether or not this complaint is covered, can survive a motion to dismiss. Okay.
Okay.
Now, as we keep going, it says, after Kiely's body was found, and authorities had publicly stated an autopsy confirmed her identity, he uploaded several videos making outlandish claims, including that Kiely and Daniel and David were not real and that the entire episode was a scam to raise money. And he also apparently, according to this, published images of Robertson and Daniel's former home address to 3 million subscribers. And he encouraged the Creek Squad to start looking for the video, and he posted Google Earth images. And one guy in particular named Julio posted videos of David's business and called people, said that they were doing child sacrifices there, and that people started flooding the internet with profiles with negative online reviews. And basically that cost the family money, in addition to the intentional grief and pain that they suffered. And they want to hold them accountable for this, okay? That's a basic overview of what's going on. Now, let me give you an overview of what I'm wanting to do. First of all, I'm going to analyze the causes of action under a purely state law rubric, okay? We're going to analyze whether this meets, assuming the facts, not the conclusions, but assuming the facts are true, whether this meets the burden under Tennessee law for defamation, for false light privacy, for intentional infliction of emotional distress, or for negligent infliction of emotional distress, okay? We're going to look at this first under the rubric of just state law.
Okay.
Then we're going to throw in the complications that might happen from the First Amendment and how that might mitigate or excuse Ryan or whatnot. And then also we're going to address a touchy topic called choice of law, because that's going to be very important, and how that could be a strategy going forward for other folks, okay? Now, disclaimer, I'm not giving anybody legal advice. The plaintiff's attorneys and the defendant's attorneys and the plaintiff and the defendant may all want to watch this, and if they do, that's fine. I'm not picking sides, but I'm going to tell you what I think the complaint, its strengths and its weaknesses, and what I would anticipate that Ryan Upchurch and his attorneys might be considering doing, okay?
Mm-hmm.
I may be wrong. I didn't sleep at a Holiday Inn last night, so I don't know. You get what you pay for, right? Okay.
Absolutely.
All right, so let's look. Starting at paragraph 23, 24, and 25, we have a statement of the parties. And it describes that they are from the different states. And then we have the issue here about $75,000. They're going to be suing for more than that. Okay. And the reason that number is critical is because that literally is in the statute. If you sue for only $75,000, you cannot get into federal court. If you sue for more than $75,000, however great or small that is, you can, as long as you have complete diversity. Now we have a paragraph here about venue, and that basically, venue is the selection of the courthouse, the specific courthouse that hears this case. And in this particular circumstance, they're saying that the Middle District of Tennessee is the proper courthouse for this, as opposed to the Western District or the Eastern District. Okay.
Okay.
Now number 28 is a curious one because it talks about a tolling agreement. Now, a tolling agreement is where the parties enter into an agreement and they say, okay, we are going to agree amongst ourselves to extend the statute of limitations so that you don't have to file suit now. You can wait and file suit later if you want to. Now, I said I practice law in Tennessee. I also practice law in Mississippi. My home state of Mississippi does not allow for tolling agreements. So this is something I've never, ever gotten involved in, because since the bulk of my practice is in Mississippi, I operate on the presumption that you don't do tolling agreements. But Tennessee allows them. And in this particular circumstance, you have to ask yourself, what does that mean? Well, first of all, that means that Mr. Upchurch already has a lawyer, and that Mr. Upchurch's lawyer has already been talking with Messrs. Robertson and Rodni's lawyer. Okay. And so there has been some form of negotiation that would trying to extend the statute of limitations. And as I believe Team Brittany has asked, if there was a tolling agreement, doesn't that indicate that they tried to previously settle a dispute? And that is correct. I think that's what it means. I think it means that, okay, look, we have a short statute of limitations, and pretend I'm the plaintiff's attorney. I don't want to have to file this right now. And I don't want, because I know this is going to be a big stink and it's going to make it all a big mess for everybody. I would rather hold off on not filing this now to preserve the statute of limitations. You, of course, get the benefit as the defendant of not having to have this in the press and having to worry about it. Plus, I think we might be able to work something out between now and then. Now, obviously, something didn't work out and they weren't able to do it. And given the fact that we're approaching the first anniversary of Kiely's untimely death, it leads me to believe that they were approaching the statute of limitations in other areas, and they just wanted to go ahead and cut their losses and make sure that we just go ahead and file this.
Right.
That's my thinking. Now, in Tennessee, you have a 1-year statute of limitations for libel, but you have only a 6-month statute of limitations for slander. And let me explain what the difference between the two is. Slander is when I speak words that are defamatory. Libel is when I type words that are defamatory. Okay.
Okay.
Now, if you go back to before the days of the internet, before the days of television, even, okay, if you go back to before those days, if I spoke something to a crowd or to a few people or whatnot, the moment I spoke those words, the words died. Now, the damage was done in the ears of anybody who heard me at that precise moment, but anybody who did not hear it would not be able to hear it again from me unless I repeated what I said, or for that matter, if somebody else tried to repeat it themselves. Okay. But with a libel, with a written piece of paper, that paper stays there until it is destroyed. I mean, I have, for example, old books in my living room that are over 100 years old.
Right.
Now, if there has been anything defamatory or libelous in those books about people 100 years ago, well, guess what? I'm reading them now.
The impact is different.
Exactly. The impact of libel is different.
Gotcha.
And so, as a result, libel has always been treated a little bit more seriously than slander in that regard. And that's reflected even in the statute of limitations in Tennessee. Now, where we get into kind of a gray area right now in Tennessee law is that the mediums that we're using on the internet are themselves recorded, just like a printed piece of paper is. Okay. And that's a good question, Claire. Does a recording count as libel or slander? It depends on the jurisdiction. And if you look at the statute of limitations as it's written in Tennessee, it talks about you have 6 months from when the words are uttered, indicating speaking. So I'm of the school of thought, if the statute of limitations, if you have two torts that could describe what you're doing, and the statute of limitations for one is 6 months and the other one is a year, err on the side of caution and file the suit in 6 months, because then you know you haven't missed anything, okay?
Right.
So the legislature probably needs to clarify that. All right, so we go back to the complaint. Now, talks about how she disappeared and that there was a GoFundMe on August 7th. And then he began posting stuff on the 13th. And he started doing outlandish theories. I'm sorry here, of what happened. For one thing, he started saying that a person named Ronnie, who was a caller to his YouTube, to a YouTube show hosted by
Icamel.
Icamel? Is that how you pronounce it?
That's how you say it.
Okay. Was a red herring and a made-up character. Now, honestly, I don't necessarily see how this is particularly relevant in this suit, because I think that can kind of bite the Rodnis and the Robertsons, because here we're describing that, I mean, yeah, on the one hand, it's showing that Upchurch has had a pattern of making slander or defamatory statements about people relating to this case. But one could arguably make the case now that they have created and said, look, there's somebody else he's defamed. And the Upchurches might come back and say, well, now this Ronnie might be a necessary party to this action, and you need to bring him in as an involuntary plaintiff, because I don't want to have 3, 4, 5, 6, 7 different lawsuits about the same thing I said. Okay.
Ooh,
right.
Okay.
Right. So that might be a two-edged sword. I mean, it shows a pattern of practice, but it also shows that other people have been damaged. And that could be a way for the Upchurch to come back and say, look, I don't, we don't have all the people at court, and some of these people, even though they may be subject to service process, maybe they're not, I don't know. But even if they are, their ability to come into this court is makes it, we need to bring them in here to resolve it. And if they can't bring them in here, that could have some place the whole lawsuit in jeopardy. Okay. All right. Right. Again, that's a matter of whether or not there's some technicality there, which I won't get into, but that's always kind of an iffy thing. You don't necessarily always want to put other people who could be suing this guy in a complaint, because if you do that, you open the door for a failure to join necessary parties. Okay. But anyway, we see how Ronnie, he's made some defamation about Ronnie, or alleged defamation. And a YouTuber comes up and says, hey, Ryan, you better be careful. You can get sued. And then Ryan says, hey, they can slander these nuts. LOL.
Yeah.
Now, I think I understand what the plaintiff's attorney was trying to do, was to say that he had knowledge that what he was saying could be considered defamatory as early as August 7th or 8th or something like that. Okay. And I think that's what they're wanting to do, but it's very dangerous to bring in other people who are not plaintiffs in here, because that in itself could create a boondoggle later. Okay.
Gotcha.
Label. All right. He also falsely accused other various YouTube crime sleuths. Zaname X and Icademel were responsible or involved in Kiely's death. Same reasons. It's kind of risky putting that in here, okay? Especially when you are speculating that Icademel was a sex trafficking code word, okay? I mean, basically Upchurch, whoever this Icademel was, Upchurch was laying it on thick on him. Mm-hmm. And this Icademel guy, may need to be brought into this suit. And if he's not able to be brought into the suit, that could pose a problem to whether or not this court would even be able to hear the case, since complete justice couldn't be afforded to all the parties. Okay.
Right.
Or because multiple inconsistent judgments could happen. In other words, Icademel could sue Upchurch and lose, but the Robertsons could sue and win. And that would not be fair to Mr. Upchurch to have inconsistent judgments based on the same body of facts. Okay. Right.
Okay.
All right. Then we get into the facts here about where the body was discovered. We see that, the police early on say this was her. And we get down to on the 23rd of August, God bless her. Everybody is confirming it's her. And the family issues a statement. And then finally, on the 22nd, Upchurch posts a video in which he appears to express his condolences to Kiely's mom and Kiely's family and Kiely's friends. Now, that is upon information and belief. The fact that he was aware that the authorities had stated they had recovered a body that was more than likely Kiely. Now, this is important for a particular reason. When we get into defamation, you have to show a certain measure of fault. And when we delve into the First Amendment issues afterwards, one of the things that you have to prove in a case where public figures are involved, you have to show recklessness. And I think this fact here is going to the heart of the fact that Upchurch may have behaved recklessly when he was saying things like Kiely didn't exist, her family didn't exist, none of this existed, because as of August 22nd, he knew not only that they existed, but he was also giving condolences to their family. Okay. Y'all see what I'm saying there?
Yes. So who gives condolences to somebody that doesn't exist?
Exactly. Okay.
This is a question. Let me ask you real quick before Higgies says, so Ikmael and Zaname could be called as witness to this case, and I believe you already clarified that.
Well, I mean, anybody who's relevant to a case could be called to it. The question here is not so much whether they could be called as witnesses, it's whether they could be made involuntary plaintiffs and be forced to sue Ryan. Now, as I was reading this could have been a message communicated to anybody who's going to be reading this complaint, like, hey, Ikmael, hey, Zaname, pick up the phone, give me a call. Hey. I mean, that could be, okay. Gotcha. It could be, you need to sue or contact us so we can bring you in. That could be just speculation. Gotcha. Okay. Then again, it could be that they were just wanting to state the facts as they knew it to establish this pattern in practice. I don't know. But what I do know is that if these people are identifiable and if they are subject to service of process under the rules of the Middle District of Tennessee, and if they cannot, the court cannot reach an agreement, not an agreement, but a judgment that affords complete relief to all the parties, then they're going to have to be brought in as involuntary plaintiffs. Otherwise, you're not going to have proper joinder of parties and the case could be dismissed without prejudice. Gotcha. And that in turn creates kind of a conundrum in the sense that, all right, well, you've got a little bit of a buffer when a case is dismissed in federal court to refile somewhere else, tolling statutes, limitations. But, when you're right up at the edge here, that does kind of make it a lot harder. So on the one hand, I see the need for listing these facts in here, but and it could also be just a subtle hint to these folks that, look, you have a claim, you might want to go ahead and sue, come on in and intervene. Then again, it might just be that they're wanting to state the facts to be open and candid with the court. But there's some risk here if they're not brought in, because if they're not brought in, then you might have a dismissal issue. Okay.
Gotcha. Thank you for explaining that. So then we were saying how in one speech he's offering his condolences, and then the next she doesn't exist.
That's right. Now it goes on to say that he promoted his own video touting his music, which would indicate he's trying to capitalize on this claim. Okay. All right. Now, on August 29th, 2022, after Kiely Rodni's body had been found and after authorities had confirmed Kiely's identity and after Kiely's family had released a public statement, Upchurch uploaded a video titled "Zero Proof of Kiely Rodni's Situation Being Real." In this video, Upchurch stated, "Everyone telling me I should be ashamed of myself. How dare you? That, oh, this is fake. Show me that it's real. Show me proof of Kiely Rodni." Also in this video, Upchurch suggested the Kiely Rodni case was a scam to raise money. I'm going to do this in my Walter Cronkite voice. Is that all right?
Please do it.
Yeah.
Go ahead.
You know,
well, okay, chat. Can you guys vote if he sounds like Mr. Walter Cronkite? Yes
how many
or no?
of y'all are old enough to remember who I'm talking about here? Okay, well, I might interject somebody else in a minute. Do you realize that you can be a millionaire on GoFundMe by catfishing people with internet deaths? You could do it as fast as F. Look at the Kiely Rodni GoFundMe. It made $63,000 in the past 7 days, and that's one GoFundMe for Kiely Rodni. If you have 5 GoFundMes for each individual person that you catfish, fake a death wish, all you need is 3 people. Goodness gracious, where's his math? I'm not even trying to.
Sir, you're doing this in a bow tie. You got my vote.
Mm-hmm. Yeah.
Oh, love it.
Yeah. So.
All right.
So show me any real proof that Kiely Rodni existing. Show me anything that indicates this is real. You can't, because it ain't. It's a scam. Well, this video had 246,835 views as of July 24th, 2023. Kiely Rodni was a real person. September 1st, 2022, Upchurch posted a video titled, "Found another picture of Kiely's CRV on Google Earth." This video was a phone screen recording of Upchurch performing internet searches relating to Plaintiff Daniel Rodni. In this video, Upchurch searched for his dad, Kiely's dad, and he posted a Google Earth recording purporting to locate Rodni's home. And then he zoomed into a pixelated image per the title of the video, which claimed was another picture. And as a result of this, Daniel essentially went into hiding. And then they go into the whole part about Kiely not being real. She's someone else. She's Hallie Ross. Trying to question whether or not Kiely Rodni's grandpa was really her grandpa. And
which I believe she was also harassed, by the way, the Kiely Ross girl.
Yeah, yeah. Now notice where it says specifically Upchurch stated in paragraph 70. I would not say, let me see if I can do this as Bill Clinton, just a second. But I would not say this unless I was 100% confident. Kiely Rodni is not real. Her grandfather is not real. Her dad is not real. Her mom is not real. All the pictures and videos you're seeing of this Kiely Rodni person are actual pictures and videos of someone else named Kiely that are 5 to 7 years old. All right.
All right.
What did
everybody
you think on that one?
I think I mean, look, everybody's saying, "Oh, excellent impersonation."
Thank you very much. I appreciate it.
And Walter wore a bow tie, so it kind of works out.
Well, you know, Mr. He did actually, come to think of it. All right, so notice where he says here, "I would not say this unless I was 100% confident." That implies that if what he's saying is false, he is speaking with reckless disregard for the truth. You follow what I'm saying? In other words, he is going double down. He's doubling down, saying that, yes, this is true. And if he's meaning that and he's saying that, he is epitomizing the standard for reckless disregard for the truth if what he's saying is not true. Okay? All right. And then he goes on. Let me see here. You know, it's been, 4 days since I made an update video on the Kiely Rodni case. Man, the comments are just flooded with the snotty-nosed effing idiots. When you going to give me that apology? I mean, you can see he's being very petulant, very childish.
Yes.
You know, and then Upchurch again directly referred to Plaintiff Robertson saying, "The grandpa, why is the grandpa on Facebook and on YouTube telling people in the comments, leave me alone?" And then he goes on to say, "There's nothing in this that would lead me to believe that this person is real. Kiely Rodni is a person. There's nothing that shows me she's real." And then he reiterates that theory. Now, as silly as that theory is, as patently absurd as that theory is, one could make the case that he's giving an opinion. Okay?
Okay.
And opinions by themselves are not, opinions are usually not considered defamation. You got to make factual assertions.
Okay.
Now, saying somebody is not real, of course, is a factual assertion. But when it delves into issues like opinion, you know, he might have a bit of an out there. Not a really strong one, but a really one. Okay. You know, so let's see here. He goes on and but in this clip on 79 and 80, he's talking about how much money he's making from this. Okay. So that's indicating the fact that his comments are really reaching a wide audience.
Right.
And that it's obvious that the Rodni and the Robertson's attorneys are trying to play up on that. So now we've got the facts. The first cause of action that they're suing is defamation, and we're going to talk about that in the context of state law. Now, we mentioned that there's two types of defamation. There's slander, and then there's libel.
Right.
But think of that as left and right, okay? There is another way of bifurcating defamation as per se or per quod, okay? Per se or per quod. So if I were to make a statement about somebody and say that XYZ person, has sex with little boys or little girls, okay, or XYZ person embezzled from a bank, or XYZ person, killed somebody, okay,
right,
that would be defamation per se, because the allegations that I have spoken are of such a variety. They're so awful, they are so demeaning that you can't help but believe that somebody's reputation has been damaged. Okay, all right.
Right.
But on the other hand, if I said that Rabbit ran the red light on 5th and Main,
yeah,
well, okay, that might be defamatory, but unless my defamatory statement caused you to suffer some financial loss, you're not going to be able to sue me for that, okay? Because that's called defamation per quod, okay? Well, there are states like Mississippi distinguish per se and per quod. California distinguishes per se and per quod. But Tennessee doesn't. In Tennessee, there is no such thing as defamation per se. Meaning, in Tennessee, you have to prove money damages when you do defamation.
Okay.
Okay. Now, this is where I see a weakness in their defamation claim under state law. Remember, we look at the complaint and we look at the facts in the complaint and we look at the well-pleaded allegations in the complaint. Conclusions are set aside, but actual factual assertions are adopted as true. The only thing that I have seen in here about them losing money, about vis-a-vis the defamation, is from this guy Julio started running down their business.
The All-American Cartel, LLC,
right?
the glitter mask guy, or one of them, whatever.
It's per se and it's per quod, Q-U-O-D.
Okay.
P-E-R-S-E and then P-E-R-Q-U-O-D. Okay.
Okay.
Right. Both are Latin terms. Commented to ask that question. So, in this particular circumstance, I think on the defamation side, they have clicked all the boxes under Tennessee law for defamation up to the point of damages. And if you look at the complaint, there is not, I don't believe, enough factual predicate to support that Upchurch's defamation caused them financial damage. Because one could arguably use as a defense superseding intervening cause, meaning this Julio guy acting on his own started doing this. I had nothing to do. Ryan could say, I had nothing to do with that. Julio is the one who did that. And therefore, if he caused you damage defamation-wise, that's not on me because he wasn't relying on anything I said, and your complaint doesn't say that he relied on what I said. He just was a member of my group, okay?
Right.
So I think that is going to be a weakness for the purposes of a 12B6 motion to dismiss on the defamation. Okay.
Right.
Now let's look at the state law claims on the false light invasion of privacy. Now that is about a bit stronger for the Rodnis and the Robertsons.
Okay.
And the reason being is nobody expects for 3 million people to know where they live and to see where their phone numbers are and whatnot. Okay. So that is a clear invasion of privacy. And I think under the facts, specifically since Mr. Rodney suffered damages in the process of having to put security up, having to protect himself,
Yes.
having crazies like the Creek Squad or whatever their names are, calling them all the time, blowing their number up, that in itself, I think, meets the test for false light invasion of privacy.
Yes.
Okay. All right. So we're only talking state law stuff. We're not going to get into the federal First Amendment quite yet. All right. So let's move now to the third count, intentional infliction of emotional distress. Now, this meets the standards, I believe, under Tennessee law for intentional infliction of emotional distress. Now, there was a case that was handed down in Tennessee a few years back. It was called
Snyder.
No. That's a federal case. That's
the federal. Okay.
The Rogers versus Louisville Land Company.
Okay.
And in Rogers versus Louisville Land Company, basically this young man died in 2001, and his mother buried him in this particular plot.
That's right.
And the cemetery people were, according to the complaint or according to the allegations by the mother, did something to deface his grave or allowed the grave to be defaced or something like that. And then they called that intentional infliction of emotional distress.
Right.
Well, the Tennessee Supreme Court in this case ruled that if you're going to have a claim for intentional infliction of emotional distress, you've got to have severe mental injury. And it is typically proven by the existence of going to therapy or going to this or going to that, or evidence of lost sleep or sleepless, something that you can objectively prove that there was a severe mental injury. Okay.
Okay.
Well, this complaint mentions that.
The therapy part.
In the therapy part. Serious mental injury, each seeking therapy for psychological injury specifically attributable and documented in the medical records to the conduct of Ryan Upchurch. Okay. That, I think, is enough of a well-pleaded aspect to get you through on the intentional infliction of emotional distress, in so much as Tennessee state law is concerned. Okay. Now, the next one is negligent infliction. Negligent infliction is the one you plead in the alternative to intentional infliction. You can't have intentional infliction and negligent infliction on the same time, because it's a function of whether or not you had the intent to harm the person. Okay. However, I'm going to pass on an analysis of the negligent infliction because the intentional infliction pretty much its basis is covered. And so if you've got that, you don't need this. Okay.
All right.
All right. So let's do our scorecard here. Because they have not alleged enough facts about financial damages in their complaint, I'm of the opinion that the defamation claim under count 1 is probably going to have some serious issues on a 12B6 motion.
Okay.
I may be wrong, but it may be some problems. Strictly about state law and state law only. Now, when we talk about the false light privacy, I think under state law, they've got a solid claim on that.
All right.
As far as the intentional infliction of emotional distress, under state law, I think they've got a solid claim there. Okay. And on the negligence, it doesn't really matter if you've got the intentional. Now, let's talk about the First Amendment. The First Amendment is going to be a bit of a problem for the Rodnis. First, let's look at the intentional infliction of emotional distress case. There was a case, you mentioned it, the Snyder case, Snyder versus Phelps, that had to do with the Westboro Baptist Church people.
Yes.
And they had gotten a permit to protest at a funeral, and they put their signs up and they did all this kind of stuff. And it was a military funeral of some sort. And they were protesting, basically the American soldier fighting for a godless country like the United States of America because of various things, which we won't get into. Well, in an 8-1 decision, the U.S. Supreme Court said that the family of this deceased person could not sue the Phelps for intentional infliction of emotional distress. No, Claire, you're mixing apples and oranges. I'll explain in a second. Okay. Because the First Amendment, you see, the First Amendment, Claire, is interpreted to the states by way of the 14th Amendment. So while the state law claim is the basis, what trumps all of that is the First Amendment. So if the First Amendment trumps anything, it trumps everything in that particular count. Okay. So in this particular circumstance, under the Phelps case, the Supreme Court and Chief Justice Roberts pretty much said, look, you have to look at these things based on whether or not there is a public interest in the protest or in the speech that is being made.
Okay.
And in this particular circumstance, because the speech that the Phelps and the Westboro people were doing was about a matter of public concern, then to punish them under a intentional infliction of emotional distress rubric would itself be punishing them for their viewpoint. And since that is not an exception to the First Amendment, whereas defamation is, the Supreme Court said that you couldn't sue for intentional infliction. In this,
I'm sorry, the note that I wrote, just to add, it says, despite the reprehensibility of the speech involved, the court improperly immunized the speech from tort liability for emotional distress on that, just so you're aware directly.
Was that from, now I sent you a law review. That was a law review article.
Yeah, that was from that. So that was like the one thing that stood out.
So that was the opinion of the law review article, right?
Yes.
Okay. So the point being is that under these circumstances, as reprehensible as what Upchurch was doing to this family, okay, that in itself may be an out for him under the First Amendment, okay, because this was a matter of public concern. You can't say it's not a matter of public concern when you've got, YouTubers from Mississippi and wherever else talking about it, okay?
Right.
And everybody around the world hearing about it. So they're going to have a tough time winning on the intentional infliction of emotional distress. As far as the defamation, First Amendment, I think they're fine on the defamation, because if it's a matter of public concern and you're dealing with a public figure or a vortex public figure, then you have to show reckless disregard for the truth. But if it's just a private person, you have to show negligence. It's clear there was negligence. It's clear there was reckless disregard for the truth, based on some of the very things that Upchurch is allowed to say, it has been accused of saying. So I think from a First Amendment standpoint, they're fine on the defamation, but they still have to get around the damages issue. Did his words, his defamatory statements, actually cause them money damages? If it didn't cause them money damages, then Mr. Upchurch will win the defamation charge as a matter of law, because Tennessee does not have defamation per se. Having said that, I'm going to put a really big star, a really big asterisk, okay, because we've got a choice of law situation that's coming up in just a minute that may turn this all around on its head, okay? All right?
Right.
But in so much as we're dealing with Tennessee law, they've got to prove damages and they've got to specify them in the complaint. Now, let's go to the false light invasion of privacy. I think that the Robertsons are probably going to be okay on that for this reason, this one reason only. When they were doxing the Rodnis and the Robertsons, it was after the child had been found.
Right.
Okay. Now, I want to imagine a scenario here, a hypothetical scenario. Let's say he had thought, okay, we got to find this car, and everybody in the world is trying to find this car. And I've got a picture of this house. This is their house. This is a pond near their house. This looks like a car. Y'all need to go check on this. Okay. If that had been the case and it had been before the child had been found, you might have a First Amendment defense there, because the public is needing to find where this car is, because they're all needing to find where this girl is. You see what I mean? Okay. Having said that, because he was making this after the body had already been found and the car had already been found. There was no public need for there to be a where the car really was type situation.
Right.
The location of the Rodni's house and the contacting the Rodni's number, for that matter, would never have fit the bill anyway. There's no public reason for that. And so in that sense, I would think that the First Amendment would not apply, or at least would not be a defense to Upchurch in that sense. Okay. So let's look at the scorecard here. Working backwards. Intentional infliction of emotional distress, it's a plus on state law, but it's a minus. It's an X. It's a no on the federal law. I don't think they're going to win on that.
Okay.
On the intentional infliction of on the false light invasion of privacy, I think it's a plus in state law. I also think it's a plus in federal law, but it's a close call. Okay. On the defamation, I think it's a plus on federal law because I think it meets the standard of the First Amendment. There's no First Amendment defense there. But if they don't have a claim for money damages that can be traced approximately to the actual defamation of Mr. Upchurch, then they've got a problem under Tennessee law.
Okay.
All right. But there's more. Let's go down to the paragraphs that we see here about damages. Now, plaintiffs specifically aver that the law of California with respect to this issue of remedies and damages should apply to this action as plaintiffs reside in California. All injuries complained of occurred in California, and treatment for all such injuries occurred in California. And the parties have no relationship with each other except through the transmission of Upchurch YouTube videos, which plaintiffs were made aware of and viewed in California. Okay. Now, that is a very, very, yes, I am married. Thank you. 26 years.
Lord, he's married. The man is married, y'all. Stop.
Yes, I'm married. Don't worry. So
that took me out.
That's a first. That kind of reminds me of a story I won't get into. But anyway.
All right.
I digress. Where was I? So anyway.
We were going to get into this. Go ahead. See, it must be the bow tie. Everybody's talking about your bow tie.
When you sue in federal court, the way it works is procedural law is used by you use the procedural rules of the federal government because you're in a federal court, but you use the substantive laws of the state that you're in. Okay. Well, one of the substantive laws that Tennessee has is a choice of law statute. And the choice of law statute says, okay, based on these various factors, if we have a tort that involves people from different states, this is what we're going to determine whether or not the law is from, if we're going to use the law of California or the law of, in this case, Tennessee, to govern the rules, govern the substance. Now, you can tell here they are actively wanting to bring damages, to use the law of damages from California. Now, why is that? Well, that's because in Tennessee, there is a $750,000 cap on non-monetary damages. So let's examine for a moment a defamation claim in Tennessee. I've got to show money damages, and I can get every last one of those money damages dollar for dollar, okay? Whether it's $1 or $20 million, okay? But the non-money damages, the damages of reputational harm or intentional infliction or things along those lines, they are capped at $750,000.
Okay.
Now, you can get a little bit more if you get punitive damages, and there's allegations that would probably allow for that. But there's a cap. I'm not licensed in California. I just did a Google search like everyone else does, and what I found on the internet about California, though, is that, and I may be wrong, and if anybody from California is an attorney and you want to correct me on this, feel free to. Under California law, there is no cap on money damages in cases like this.
Okay.
So if you're suing a guy who has 3 million YouTube subscribers, and let's assume in the course of a year, each one of those subscribers give him a $1 super chat plus, he makes the money from the videos, and he makes, anything he gets from monetization from YouTube or whatnot. You can imagine he's probably bringing in some serious dough off his YouTube channel. Okay.
Right.
And $750,000, though, is a lot of money. It's not nearly as much money as he's got. So you could understand, oh, he's not monetized? Oh, well, at any rate, assuming just you have somebody who gives one of your commenters saying he's not monetized.
Is he not monetized out of, his videos or the videos that he made from Kiely Rodni? And that has been a thing that people have said, well, he's not monetized.
Well, even so, I'm sure he's making revenue from his videos and whatnot, and if from his music videos and the music he's buying and things like
right.
that. In other words,
on YouTube.
Yeah, so. Yeah. And he may be getting money from Patreon. He may be getting money from other sources. The point being is, if you've got 3 million subscribers who are willing to throw you a little bit of money, that's going to be a heck of a lot more money than if you have 300 subscribers like yours truly, who's just getting started. So, suffice it to say, there's a lot more money there than $750,000, presumably. And as a result, they're wanting to bring, by way of choice of law, the damages statute from California into this case. However, choice of law also goes to the substantive issues, and more so. And that's important because up to this point, I've been talking about how Tennessee does not have defamation per se. Okay?
Okay.
But California does. And the standards for defamation per se, again, I'm not a California lawyer. I'm not giving any legal advice to anybody for that matter. The California defamation per se statutes seem to be looser than what I'm even used to here in Mississippi, where I live.
Okay.
So, by way of choice of law, if the federal district judge uses California law as the substantive law, then, you remember when I said a while ago, the First Amendment box is checked for defamation? Well, guess what?
Yes.
Now, the state law box is checked for defamation. Okay?
Okay.
All right. So, they're really going to want to have California law to govern this case. Okay? But there's a downside with that. Because as I mentioned, you can't do an anti-SLAPP motion in the federal district court in the Middle District of Tennessee. But you could do an anti-SLAPP motion under California law in the district courts out in California because the Ninth Circuit says that you can. So it would be a big crapshoot, but Upchurch might just say, well, screw this. Let's just move for forum nonconvenience and move the whole thing over to California, and I'll defend it there. And that would be an option. No,
wow.
That would be an option. So, that being the case, they may not necessarily be wanting to bring attention to that. Okay? Maybe, maybe not. So, we'll just see. We'll see. But that's basically the status of this case. There's a lot of as Will Ferrell used to say, a lot of strategery. I think there's already been some negotiations going on, as evidenced by the fact that there was a tolling agreement.
Okay.
Apparently the negotiations fell through because they went ahead and filed suit. So we'll just have to wait and see how this goes. It could be that Upchurch's people might try to move under the anti-SLAPP anyway, knowing that they're going to get shot down, and maybe ask for that to be done on appeal in the Sixth Circuit in Cincinnati, which is the circuit that covers Tennessee.
Mm-hmm.
I don't know. But all in all, I think this is a very good complaint. I thought it was very well written. Might have need to beef up the facts a little bit more on the issue of money damages.
Right.
I might have, this is just a matter of preference. I probably would have tried to de-emphasize what had happened to Zanny, May, X, or anyone else, just to ensure that there's no
Others.
there's no issue of lack of joining necessary parties.
Right. Right.
But it's possible that that's not even requisite anyway, and they may not raise that defense. But otherwise, I think it's a very good complaint. I think they're going to definitely have a sympathetic jury in Middle Tennessee. That's for sure. If it
Mr. Matt, I didn't write this complaint, right? It's not fake. I didn't write it. I just want to make sure.
No. It's definitely done. And let me look at something on here. Very interesting.
Yes.
Notice at the very bottom of the complaint, the banner at the bottom, that is noting that this is the case number for the Middle District of Tennessee, the filing and whatnot. Yes, the Rodnis do have a good chance still.
They do.
I mean, at the very least, no matter which way you look at it, I think they've got a very good shot on the invasion of privacy. I think their intentional infliction is a weaker case, and the defamation case depends on one of two things. It depends on whether or not you use the California choice of law, whether you have the California choice of law, or whether they're able to amend their complaint to add more specificity with respect to the money damages that he may have suffered with respect to the defamation that was directly attributable to Mr. Upchurch.
Right.
Okay. Now, of course, this is court. Mr. Upchurch may come back with an answer of his own, and his answer may have some affirmative defenses that we've talked about today, or that he's not even thought of, or I've not even thought of. And of course, he's entitled to his day in court, and he's entitled to all the presumptions that accrue to anybody who's in court. Again, I'm not taking sides. I'm not saying he committed defamation. I'm not saying he didn't. I'm relying strictly on these facts that have been presented. If it turns out any of these facts are false or wrong or incorrect or anything along those lines, then of course that changes everything. But we are relying upon what has been presented in a public pleading that is a matter of court record, and I'm just commenting based on that and what I think an attorney would do to react to this, or what a plaintiff's attorney might do in the various negotiation postures that you see.
Wow. This is going to be intense.
Might be. Might be.
It's going to be intense, So I guess we'll see what goes on next,
Yeah, I figure this is one of those things that will, if it does stay in the Middle District of Tennessee, and there is no change of venue, and they proceed in the very near future, after any motion to dismiss or disposed of, the court's going to have a scheduling conference. That scheduling conference is going to set the boundaries of discovery, and then you're going to start having depositions, and you're going to start having interrogatories, requests for admissions, the various litigation that you come to know and love. And then if they aren't able to settle it or mediate it, and if it survives summary judgment, then they'll end up going to trial, and then it'll be interesting. But honestly, I think it'll resolve one way or the other before then.
Okay.
Either by way of a settlement or by way of some sort of dismissal, but we'll see.
Somebody said here, question, the intentional damages, could that have changed over a course of time? Because I believe at some point he knew he was causing damage to this family.
Well, it's not so much the question of damage. It's a question of is the court going to punish him for having a crazy viewpoint?
Okay? Yes.
All right. It's all a function of the First Amendment and whether or not his viewpoint is being punished as crazy as his viewpoint might be, as painful and as ridiculous and as much infliction as that viewpoint might be, the First Amendment may protect that. Now, having said that, if somebody performs actions that don't have a speech component to it, and want to inflict misery on someone, like maybe doxing their phone number or something, and knowing that recklessly that hundreds and thousands of people are going to start running the guy's phone bill up or start calling him up all the time. Now that still could be intentional infliction. At the very least, it even could be negligent infliction if that caused bodily injury or physical harm or pain to the other party. But if we're talking about strictly what he has said on Facebook or YouTube, I should say, in the context of the Kiely Rodni disappearance and the search for her and any of his opinions and his theories, then they're going to have a tougher time arguing the intentional infliction of emotional distress just because of the Snyder ruling. But they can get them in some other area, like the defamation or the false light.
Goodness. Wow. Like I said, it sounds like this might be a little bit intense. We'll see what happens, I guess. I don't know. I'm sure a lot of YouTubers will be giving commentary to it and or reviewing it as it's playing out. Or maybe they'll just settle. I don't know. I'm just thinking maybe they'll just settle. He says, Claire says, basically, it will be difficult to prove that he didn't believe the things he was saying and intended to hurt the family by making things up.
Well, no, it's not even a function of whether he truly believed it. It's a function of whether or not he had a reasonable basis to rely on the information he was given. In other words, all right, let me put it this way. All right, let's use what we're talking about right now. Okay. In the context of this, we are relying on a complaint. And this complaint is a matter of public record. And in my speaking about this case and saying what I believe Upchurch did or didn't do, I am relying on a court document that I see right here. Okay. And I can point to what I'm relying on. Now, I may be dead wrong. And the reason I may be dead wrong is because the Rodnis and the Robertsons might be wrong. Okay. But because this is a matter of public concern, Mr. Upchurch is a public figure. If I'm mistaken in anything I'm saying, I can't be charged with recklessness because I have something with a reliable source that I'm relying upon. Does that make sense?
Okay. Yes. Yes.
So it's not whether or not I truly believe it or not, or whether or not Upchurch truly believed it or not. It's a matter of whether or not he thought he could back it up. And when he says he is 100% confident about something, then that means if he doesn't have factual predicate to back that up, or if that factual predicate is so off kilter, then that's going to be considered recklessness.
Right.
So I don't think they're going to have a problem under New York Times versus Sullivan getting this guy because of the sheer recklessness of what he's saying.
Okay.
But the question, however, is going to be whether or not under state law, if Tennessee law is adopted, whether or not there is enough allegations in the complaint to show that there was money damages for what he suffered, what they suffered.
Gotcha. So then Declare says, oh, so in that case, him saying they aren't real, but they are, he could be held accountable.
Well, again, that depends on whether you're using Tennessee law or California law.
Right.
In Tennessee, all right, let's say somebody said, in Tennessee said that Matt Wilson is not real. Better ask Matt is not real. Okay.
Okay.
Now, unless I could show that lie hurt my business because people were no longer coming to hire me as a lawyer, thinking, okay, well, he's not real, I'm just not going to hire him. Then I would not have suffered money damages that I could attribute to that defamation, and therefore I could sue him for under Tennessee law. Okay?
Gotcha.
But in a state where defamation per se exists, even then, that's a function of the various laws. For example, defamation per se in California is different than what it is in Mississippi. There are some things that are per se defamatory in California that are not in Mississippi. So even that varies from state to state.
Right. So I mean, it depends then, I guess.
So it depends on which choice of law is going to be used in
Right.
in this. Yeah.
It depends. I think that's the only way to say that. Depends. Wow. I guess we will see how all of this kind of plays out, right? And I know a lot of us will be interested to see how it all plays out at the end. But it definitely sounds like it's going to be intense. And a lot of people here in the chat are, they're very concerned, and they definitely feel like he needs to be held accountable as, the family does as well. So I
Now,
guess we'll
one
see.
of your commenters said something, let's see here, from California, and they filed in California, then that would cause Ryan to have to travel to California, yes or no, or possibly. Well, that gets back to the whole issue of personal jurisdiction.
Okay.
Based on the facts of this case, it's it's not a solid case that enough case for Ryan for the state of California to say that Ryan had jurisdiction over him. Okay. And so, because there's a question about personal jurisdiction, if they had sued in California, chances are the case would have been dismissed in California for lack of personal jurisdiction.
Yes.
Okay? All right. But if they could have survived the personal jurisdiction argument, then they could have brought him to California to stand trial, or he might have ended up getting sanctioned a big way for not coming and gotten a default judgment or something like that. But that's just hypothetical at this point.
This comment, under the influence of illegal drugs, would show his intentional reckless behavior. I mean, but how do we know he was using illegal drugs? One can assume.
Well, whether he's using illegal drugs or not is immaterial.
Yeah, I didn't think that was an issue.
And the reason why is, let's say he's this stone cold sober and he's taking this kind of recklessness, then fine. And if he wants to use, well, I was drunk, well, you chose to be drunk. So either way, it's not going to fly. Who leaves you up to the choice of law of the judge? Well, the judge would be interpreting Tennessee's choice of law statute to determine which body of law. In other words, here's the thing. If the judge in the Middle District of Tennessee handles this case, he's still going to hear this case unless the matter is physically transferred to California. But even if it stays in Tennessee, the judge in Tennessee may choose to apply California law to this basis, to this
matter. Gotcha.
Okay? All right. And that's going to be a function of his interpretation of Tennessee law when it comes to the choice of law or conflicts of law.
Gotcha. Give me 1 second. Give me 1 second. And then someone who decides which court system is California or Tennessee?
Yeah, that's what we're talking about. The court system, first of all, the court system that's being used right now is the federal court in Tennessee because the plaintiff picked their forum. Okay. Now, the question is whether the judge in Tennessee is going to use the law books in Tennessee or the law books in California.
Okay.
In other words, which rules are they going to be playing by?
Gotcha. Okay, thank you.
Think of it this way. Here's a very good way of describing it. Okay. All right. Imagine it's the World Series. Okay, and you've got the American League champion and the National League champion. They're playing each other in the World Series. Okay. And when you're in a National League ballpark, you're going to play by the National League rules. And when you're in an American League ballpark, you're going to play with the American League rules and have a designated hitter. Okay. And the pitcher won't bat. Okay. It's a similar question. It's a question of which rules from which jurisdiction, which league's rules are we going to use? We're still going to play the game in Tennessee. It's just, are we going to use Tennessee's rules to govern the dispute, or are we going to use California's laws to govern it?
I got you. Well, Mr. Matt, I appreciate your time. I'm having to head out. I appreciate your time and just
thank you so very much.
No, this is awesome. You guys, I linked Mr. Matt's channel in the description box as well as in the chat. It's pinned up there. Check him out. He says he's going to do a lot of videos today, right?
Lord willing, if when I get some time.
No, this is awesome. Like, it just helps. It helps channels like myself and other channels to have, legal professionals come up and just give us commentary to this. So I appreciate you even being available.
Okay. All right. We'll
Thank you
talk to y'all
so much.
later.
All right. You have a great one, guys.
All right,
Oh,
bye-bye.
you have a great one, sir. Bye. Guys, let me know your thoughts in the comments about this situation. It's very informative. It's a lot of information, a lot to sink in. And I guess we'll see what happens next here, right? And again, I wanted to give you guys an objective view because I didn't want you to think, anybody to think, well, this is, no, this is somebody who doesn't have any skin in the game as far as he's just giving us the facts and laying out the laws as they are. Nothing to do about what team he's in or anything like that, which I think is very important. You guys let me know your thoughts in the comments. If you're watching the replay, please hit that like button. And I will see you guys later on because we are got a couple stuff on our agenda today. I'll see you guys in the next one.